I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, we are stepping into number 97 on our compilation list, and we are in 3 different judges' courtrooms for this compilation. Just want to say thank you guys for all of the support of the channel. Thank you guys that have been, doing the polls that we've been putting in the community posts, asking you guys which judge do you think had the best compilation when it came to focusing just solely on one judge. Most of the compilations we do is a mixture, but there are about 10 or 11 compilations that we did where we only focused on one judge. Now, once again, we will be in 3 different judges' courtrooms. There will be no commentary added to this video. There will be chapters added just in case you want to skip over a particular proceeding or skip around and watch them however you want to watch them. And don't forget to like, share, comment, and subscribe. Many of you have been in the comments talking about how much you don't like the AI channels, the bot channels. So, if that's the case, you like to hear a human voice, please share this some way, somehow, whether it's through a text message on your phone or somewhere on social media. It would be much appreciated. Now, the judges' courtrooms that we're going to be in on today. First, we will be in the courtroom of Judge Nicholas Thornton out of the state of North Dakota. Second, we will be in the courtroom of Judge Victoria Shackleford out of the state of Michigan. And last but not least, we will be in the courtroom of Judge Jason Elmore, also out of the state of Michigan. Guys, we are rolling along with these compilations. We also have some individual appearances that we've been putting out recently, some new appearances of some of the sovereign citizens court cases that's been coming up. So be on the lookout for that. Some of them we will be adding to the compilations instead of just featuring them by themselves, depending on the length of those appearances. So just keep that in mind. So that way you can know what to look out for. Don't think just because it's a compilation, it's not going to have new proceedings in them, because we have been putting new proceedings in our compilations as well. Now, enough of the talking. Let's get ready to go ahead and run into number 97.
All right, next cases the court's going to call will be State of North Dakota versus Michael Scott Jacobson, file 26, 2023, CR 36, 26, 2023, CR 16, and 26, 2023, CR 50. Present in court, Attorney Mary Depute for the state.
I'm here by special appearance as the executor.
Please have a seat. Please have a seat. Mr. Jacobson is personally present and without counsel. Sir, good morning. Were you present in court when your rights were read to you earlier?
Sir, I don't consent to this hearing because of lack of jurisdiction of the court over me. I'm not a 14th Amendment citizen anymore. It's in my documentation that no one ever reads.
Sir, I asked you a question.
I told you.
So,
I am not,
sir,
I'm not.
sir, stop talking over me. I'm going to ask you a question and you're going to answer the question.
I don't understand.
So I'm asking you, were you here when the rights video was played not once, but twice this morning?
I was here.
Do you understand the rights as they were read to you?
I don't stand under anybody.
I'm asking if you understand the rights that were played for you.
I don't understand.
Okay, so let's talk about what you do and don't understand, sir. Do you understand the English language?
You do not have jurisdiction over me. If you look at the documentation.
Answer my question, sir.
You do not have jurisdiction over me.
Answer the question, sir. Do you understand the English language?
I don't understand.
Okay, so I'm asking you if you understand the English language.
I don't stand under anybody.
Sir, I'm asking you if you understand English. I asked the question in English. You responded in English.
So
I think you understand.
What's your answer?
But I'm making a record, sir, to make sure that we're clear.
My record is you don't have jurisdiction over me.
And
I'm not a 14th Amendment
Sir.
citizen, person, or resident.
sir,
You even know what I've done? I've changed my jurisdiction. I've gotten out of the jurisdiction of the water and I'm back on the land.
Sir.
Where I'm alive. I'm a living, breathing soul. And you cannot contract with me anyways.
Yeah, I'm not contracting with you at all. I'm asking you if
That's
you
what this court is trying to
Sir,
do.
stop talking out of turn. Are we clear? I'm asking you, do you understand the English language?
You've answered that already.
So your answer is yes, you understand.
You answered it.
I'm asking you to answer it, sir.
You've answered it yourself.
It's not for me to decide. It's for you to put on the record whether you understand the English language or not. Do you understand what I'm saying to you?
I don't stand under anybody.
That wasn't the question.
We're not going to get anywhere. You do not have jurisdiction over me.
Sir,
If you had read my affidavit,
were you present in court when your rights were read to you earlier?
I've been in court many times and I've heard those rights.
And so you understand those rights.
I don't stand under anybody.
That wasn't the question. Do you understand?
That's what you're asking me to do. I don't stand under you.
Sir, you've already said you made a special appearance. So I'm asking you if you understand. Do you understand?
I comprehend them.
Okay, comprehension is good enough. You comprehend them. All right. Do you comprehend that you have the right to an attorney?
I don't need an attorney.
Do you comprehend that you have the right to either an appointed attorney if you financially qualify for one, the right to hire an attorney of your choosing, or the right to represent yourself if you can do so knowingly, voluntarily, and intelligently?
I don't consent to this hearing because I'm not under your jurisdiction. I'm
Sir?
under the jurisdiction of the land.
I
Not in the
understand.
jurisdiction of,
Sir?
of your contract law.
Okay. Do you comprehend your rights to an attorney?
I don't need an attorney.
Has anyone threatened you, forced
No one has
you?
threatened me.
So let me finish before you start talking. Sir,
I've been here the last 7 times.
stop.
Nothing has happened. Read the
Stop.
file.
Sir, stop interrupting. Stop trying to talk over me. I'm asking you a question. Has anyone threatened you, forced you, or coerced you, or in any way made any promises to you in order to get you to waive your right to an attorney?
No one has.
Thank you. So we are here today for a number of dispositional conferences. A dispositional conference is a conference set to determine how you intend to proceed.
Your Honor, if I could interject, I'm sorry, but I think there's a little more complexity to this procedural posture. In case 16, the defendant had filed a motion to dismiss. The motion to dismiss, the response was filed with the state on June 28th. At the last status conference, the defendant wished to raise the same motion in all 3 of his cases. At that time, it had not been served in the 2 remaining cases. Although the motion still has not been served, it has been filed in the 2 remaining cases. And so I believe that there is a pending motion before the court in all 3 cases.
So this wasn't noticed as a motion hearing. Rule 3.2 requires that the moving party file a notice of motion declaring whether or not the motion is to be heard for oral argument, to be heard for an evidentiary hearing, or to be considered under briefs. That notice of motion wasn't filed, requesting a hearing. So today it's not properly before the court, even if it was properly served.
I brought it to the court.
Sir.
I could not get a hold of Ms. Pugh. She would not
So
return my
stop.
calls.
This is where I'm talking. So those motions have not been served. So technically, even if the state's filed a response, they're not ripe for the court's consideration. So the court is not going to take up motions. Furthermore, these are Judge Naram's cases. I'm not going to rule on motions in Judge Naram's case or cases that are not properly before the court and noticed for hearing. So as far as the court's concerned, all that's before it today properly is a dispositional conference. Sir, you have 5 options at a dispositional conference. You can schedule it for a jury trial. You can request a bench trial. And if the prosecutor agrees and the court agrees, the court can schedule it as a bench trial. You can request a continuance. You can change your pleas from not guilty to guilty today. Or you lastly can choose to schedule a change of plea for a later date.
Well, let's do a continuance until Judge Nicholas gets the case so he can make a decision on it.
All right, so what I told you before is right now, those issues aren't properly before the court because they haven't been served properly following the rules.
Serve them properly, we'll just do a continuance then.
All right, Ms. Depute, your thoughts?
That seems appropriate to me. I believe at the last, maybe there are not notes on the docket. I believe it was contemplated by the previous judge that this would be a motion hearing. It was discussed at that time. The state is ready to proceed. But if Your Honor doesn't wish to hear it today, then I believe continue it until Judge Nicholas could hear the motion would be appropriate.
So, okay.
Could he make a decision before you even go back to trial? I suppose I have to file that.
Yes. So Judge Naram's next court date in McIntosh County is 6 weeks away.
That'd be fine.
It's November 13.
We can't get nothing done if there's another judge here. Gotta have Judge Nicholas.
Well, he is assigned to these cases, and typically once a judge has been assigned, unless there's an agreement or stipulation between the parties, I'm not going to sign a motion or consider a motion that wasn't on the docket as a motion hearing. So I will continue this matter, all three matters, for a dispositional conference and a motion hearing for November 13 before Judge Nicholas. It'll be set at 9:30 a.m., but I'm sure Judge Nicholas will call that case last. Just so you're aware of that. Mr. Jacobson, it probably will be late morning before that motion is heard. Ultimately, Judge Nicholas will be able to decide the motions, assuming that they are properly before the court at that time. And so that means proper service, proper notice of motion. You'll need to file a 3.2 notice of motion that declares whether it's for evidentiary hearing purposes, oral argument hearing purposes, or both. And at that time, Judge Nicholas can make decisions. So that'll be the decision of the court today. Continuance in all three files until November 13 before Judge Nicholas at 9:30 a.m. Anything else, Ms. Depute?
To clear up part of the record, in case 16, it was noticed as a motion hearing. I understand the judge's ruling. I just want to make sure that what's represented is correct. But other than that, I have no further comment.
Yeah, because I remember him telling me to file motions for the other three, put them all three on the same date.
Yeah. So as a matter of judicial economy, even if it was, it's not an odyssey. The code that I was looking at isn't an odyssey saying that it was a motion hearing. But the notice of hearing document does say and motion hearing. But in the odyssey record, it just says misdemeanor dispositional conference on file 16. On the others, it has not been cleared up. So in the interest of judicial economy, those will track together if it's the same motion in all three files. So, all right, with that, we're adjourned in this matter. Thank you.
And then we've got Mr. Martin.
He claims to be an attorney, so here to speak with Mr. Fanbro.
I'm looking forward to it. All right, this is 241388, the state of Michigan versus Eric Joseph Martin. Sir, can you tell me your name?
Oh, not the Roman Sesticate Trust, if that's what you're wondering.
Okay. Are you going to tell me your name or not, Mr. Martin?
Well, I just want to make it clear, I'm not the legal fiction corporate entity defendant.
Okay. All right.
If I give
Sir,
name.
If you require accommodations to use the court because of disabilities, or If you require a foreign language interpreter to help you fully participate in court proceedings, please let the court know immediately. You are here today on count 1, domestic violence. There's an allegation that on June 8th of 2024 in the city of Taylor at 9074 Clifford, that you did make an assault or an assault and battery upon Crystal Nicole Martin, a resident or former resident of your household, contrary to MCL 750.81 parent 2. This is a misdemeanor punishable by up to 93 days in jail and or $500. A consecutive sentence may be imposed under MCL 750506A if the assault was committed in a place of confinement. Those are the charges against you. You've been brought to court on a misdemeanor charge, and you have the following basic rights: to plead guilty, not guilty, or to stand mute. If you stand mute, a plea of not guilty will be entered, and you may plead no contest with the permission of the court. You have the right to a trial by a jury and to have the assistance of an attorney. You have the right to an attorney appointed at public expense if you are indigent, meaning you cannot afford to pay for an attorney. If the offense requires a minimum jail sentence, this charge does not have a minimum jail sentence. The court determines that it might sentence you to jail, and the appointing authority, which is the court, would decide if you are indigent and appoint counsel if you are eligible. You may have to repay the expense of the appointed attorney, and you may contest your ability to pay the ordered fees if the court attempts to collect any costs for an attorney, and the court must then determine your ability to pay. Mr. Fanto, a court-appointed defense attorney, is present in the courtroom. It's my understanding he attempted to meet with you, and he was advised that you did not want to speak with him. Is that correct?
Because of the unfairness of the laws that would fraudulently assume if I take a lawyer that I would be giving up my right to be one of the sovereign people and be fraudulently assumed to be a legal fiction defendant. Yes, I have refused that a lawyer
Mr. Martin,
me.
If you have a trial, you have the following rights: to call witnesses to speak for you at trial, and you could get an order signed by the court to require those witnesses to come to court. You have a right to see, hear, and question all witnesses against you at trial. You have a right to be a witness for yourself or to remain silent. And if you chose not to be a witness on your own behalf, the prosecuting official could not comment on your refusal to testify. You also have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. If you plead guilty or no contest and your plea is accepted, you will not have a trial of any kind, and you will give up the rights that I just listed to you. You also have the right to be released on bond. If you are now on probation or parole and you enter a plea of guilty, or a finding of guilt is made by a judge or a jury, it may result in a violation of your probation or parole. The court can sentence you to jail and fines plus cost, and the court must tell you on the record the name of the offense, the mandatory minimum jail sentence, if any, and the maximum possible penalty for the offense, including jail, fines, and both, which I've already done. Fines, costs, and other financial obligations imposed by the court must be paid at the time of assessment, except when the court allows otherwise for good cause shown. If you are not able to pay due to financial hardship, you can contact the court immediately and request a payment alternative. So those are your constitutional rights going forward, Mr. Martin.
I want to make it clear I have been illegally arrested here by Barbara Wade, okay, because he just went by her lies saying I kicked her. As soon as he walked through my door, I'm the one that called 911 on Crystal Martin, okay?
All right, sir, you have a constitutional right to remain silent, and anything you say with respect to this case could potentially be used against you in a court of law. So I would advise you at this time to remain silent with respect to the actual facts or allegations listed in the complaint and misdemeanor complaint, which I've read to you. Sir, are you gainfully employed?
Well, I wish to finish, before I answer your questions, I will answer your questions. I want to finish exercising my First Amendment right, freedom of speech, and continue what I was saying. Now, again, I
Okay,
was
sir,
arrested
you are
illegally.
to appear in court as directed. I'm not going to argue with you, Mr. Martin. I understand your sovereign citizen argument. It's not the first time I've seen it or heard it. You are under the jurisdiction of this court. This court has jurisdiction under the Michigan Constitution and the laws of the state of Michigan. You are charged with a 93-day misdemeanor, sir. You've been advised of all of your rights. Okay, you have a First Amendment right, certainly, but you are here for an arraignment, not to lecture me on sovereign citizen beliefs, okay? I'm trying to get you through this and make sure you understand the process. You are to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You're to have no contact with the complainant, Crystal Martin, in this case. Do you understand me?
No, I do not understand, in that I do not stand under the charges, the false fraudulent charges, but I do comprehend. But as I was saying, I was illegally arrested in violation of my due process rights. There's not sufficient evidence for my arrest that I did any domestic violence. Bardaway just arrested me anyway. There's no video of me assaulting her. She did not see me. She just told a lie. I actually filed a PPO on her.
Sir, do you understand that you're not to have no contact with Crystal Martin?
Then you need to tell her, do not come to my house. She keeps coming to my house so she can set me up with these lies because my sister
You're not
over. I have no, I don't want to contact her, but she needs to stop coming over to my house. You know, I've been living there for 36 years.
Miss Maudlin,
Let me finish talking. I have the First Amendment right to talk. I have the.
Mr. Martin, it's clear to me at this point that you have no respect for the court. I believe that you're a danger. I can't get any information from you as to whether or not you have another place to reside, whether or not you understand the court's no contact provision. I need to know that you understand what I am telling you, because I am attempting to set a bond on your case. And if you want a bond on your case, you've waived your right to an attorney. And I'm trying to figure out, do you have another place to stay? Do you understand what no contact means? And if you're not going to express to me that you have an understanding of what I'm saying, and if we can't get on the same page about that, then I'm inclined to not give you a bond. Do you understand me, Mr. Martin?
I comprehend you, yes.
Okay, do you understand that I said you were to have no contact with Crystal Martin?
Yes, but she needs to stop coming over to my house. I'm not trying to contact her. She's coming over to my house so she can make false allegations like this, set me up so she can have the whole house to herself, her and my sister. This is what the whole agenda is of her with my sister. Lisa Martin tried this before, even though I proved to the court before the video of my sister Lisa Martin trying to set me up with lies and try swinging at me, assaulting me. I have this on video saying that Crystal Martin here. I have her on video swinging at me and dealing with the prior case she tried to bring against me. Okay.
So,
well, I have evidence that she is aggressive towards me.
Mr. Martin. Does Crystal Martin live at the home on Clifford Street?
Yes, she comes over like for a day or two, and my sister lets her come over, and she stays there for a day or two. Yes, and then here and there.
Okay, so your sister owns the home.
No, she doesn't own the home thing. So my understanding is the bank really owns it. It's always been like my parents' house. But I don't even think really my parents own it because they didn't finish paying off the mortgage or whatever. So I think technically it's the bank's house, but me and my brother and sister have been staying there for a long time. Me there for like 32 years. My parents have passed away now. So now it's like a fight with them two. They're trying to take over the whole house by coming with false allegations, by telling cops, oh, he assaulted me all the time. There's no evidence. It's not true. It's a lie. There's insufficient evidence in violation of my due process rights. But Bardaway arrested me anyways, and this is just what she wants. So they can have the whole house to themselves. I even filed a PPO on Crystal Martin.
All right, so you're not to have contact with Crystal Martin. You're not to return to 9074 Clipper in the city of Detroit, or in the city of Taylor, I'm sorry. You're allowed.
Objection, it violates my due process. You cannot deny me my right to live at my house because of an unsupported allegation by her, which is a lie at that. Like I said, the cop had no sufficient evidence. She just told a lie, and the guy didn't even bark away, that is, the police officer, just came to me and arrested me right off the bat. That violates my due process rights with sufficient evidence.
Sir, you're allowed one visit to the premises to obtain personal belongings. You must be accompanied by a police officer.
And I want Barbaway. Well, hold on, I'm gonna let you finish. I'm just gonna finish what I got to say, so you don't cut me off. And I want Barbaway arrested for his illegal arrest. I want Barbaway arrested for illegally arresting me. I want him charged for assault and battery, for illegally arresting me, and kidnapping.
Okay.
Because it was without my consent.
Mr. Martin, if you are not allowed at the 9074 Clipper Street address, where will you be staying?
I am allowed. I don't have nowhere else to live. That's my house. I'm allowed there. You ordered that, it's illegal. That violates my due process.
All right. He has a $2,000 cash bond with a GPS tether.
Yes, objection. That violates my right to a personal bond.
He's not to appear at night.
Innocent without guilty.
He cannot come to 9074 Clipper or be in contact with Crystal Martin.
And now we are down to people of the state of Michigan versus David Thompson, file 24-35559FH.
Yep. David and Houghton, appearing on behalf of the AG's office.
You know, Mr. Thompson is representing himself, and I'm advisory counsel in this matter, but I can advise the court there is no other agreement.
All right, so Mr. Thompson is now here. They can go to the defense table.
Yes. Oh, sorry.
Just call me David, you're on.
All right, well, all right, so we are currently set, so you can have a seat. Just as you may have heard me say earlier, don't take any thought. I have nothing to know about the case. I'm just going to tell you that, as I do to anyone here for a final pretrial conference. Today is the last date in which to enter a plea pursuant to any pretrial agreement. Any plea from here on out must be done by entering a plea as charged. The reason I do that isn't to punish the defendant, isn't to punish anybody or encourage a case to go in any one direction. It's just to encourage you all to exhaust any negotiating that you've got to do, because everybody's got to issue subpoenas. Subpoenas have to be served by police officers or process servers. My staff has to issue jury notices. 60 different jurors have to reschedule dates and times and take off work, and employers have to do the same thing. So again, there's no punishment. It's just to make sure that we have exhausted all of our negotiating skills. So we have no resolution. The case is currently set for a trial right now. I know we have two trials set for February 18th. Excuse me, this one is set for 1 day. The other one was set for 2 days.
And I was going to, on behalf of the AG's office, I think that they're planning on it, ask that perhaps we keep both of those on. The idea being that we'll be able to conduct both of those trials in that 2 day time frame.
And was there a jury demand, I assume?
There was, yeah.
Right. I'm going to move this to start on February 19th. So that way we have the 1 day to do the other file and the second day to do this case. So I'll issue jury letters to 4 sets. 4 panels, 2 for each day. So Mr. Thompson, that means that even though your notices say that our trial was to begin on the 18th, we're going to begin it on the 19th. We do jury selection in the morning. I need to remind you that your choice to represent yourself, you're making that on your own. Is that correct?
That's correct.
You understand the court can appoint an attorney to assist you?
Yes,
yep. I know. Yeah, I know he's helping you, yes. But you understand that he's not really representing you. Like, in other words, he's not doing the cross exam, direct exam.
That is correct.
All right, and you understand that while it might seem illogical, I have to, by law, require you to follow the same rules in the courtroom, okay? So if you need to enter a piece of evidence into, an exhibit into evidence, you're asking questions, you're gonna have to follow the same rules, okay? And just make sure you say yes.
Yes.
Thank you. Every person has a right constitutionally to due process, and every person also has the right to represent themselves. And again, I also just needed to make sure today that you are making this choice to continue without counsel. In other words, representing yourself on your own. Is that right?
That is correct, yes.
And the key issue when I say on your own, no one's forcing you, no one's pressuring you. It's your choice.
They are not.
Okay, copy that.
May I?
Yes, sir.
It's my understanding, Your Honor, that there's a conflict of variance in the law, equity should prevail. I'm prepared to wrap this up and settle all of this. I've done here in this venue that's exclusive of Article 3. Constitutionally speaking.
Yeah, I appreciate, I appreciate that interest, but I can't. And let me explain to you why, very briefly. The law and the constitutions for both the state and the United States direct that each side, and that's important, each side has the right to a trial with a jury of 12 impartial persons. And I'm really just sitting here, I don't know anything about the case other than what I see on the charge sheet, which just tells me what there's 2 charges of failing to pay child support.
Correct.
If you all can't negotiate that between you, I don't really get involved other than monitoring the cases and making sure I know when I've got to be here and what's going to trial. I don't get involved. And even now that we have a trial by jury, I'm not involved other than I'm telling that I run Tiger Stadium here. I mean, this courtroom, and this stadium will be available for the 2 parties. That's it. Okay. So I appreciate that might be your interest and that might be an objective. I can't make a ruling unless there was an appropriate motion. Now, in a criminal case, you can't file a motion to dismiss. I'm always surprised by how many attorneys, not these 2 gentlemen, would file a motion to dismiss in a criminal case. You can't do it. You can in a civil suit. That would be different. But here, we can't do that. The law does not allow me to resolve this case unless you are all doing a trial without a jury. Since you're doing a trial with a jury, all I'm in charge of is monitoring Tiger Stadium. Okay.
Could you please repeat yourself the last 2 sentences, because I heard something in there. I want to make sure I heard it correctly.
Hopefully I got it right. You can't do a motion to dismiss. Well, you can in the middle of the trial when the prosecutor rests. If the prosecutor doesn't prove each element, then you can do a motion for a directed verdict pursuant to Michigan Court Rule 6.429. Either 429 or 419. I think it's 429. You can do a motion for a directed verdict at that time. Until we get there, I can't dismiss a charge. There's some other rules, like if he violates the 180-day speedy trial clock, right, and you're sitting in trial in jail. But other than that, there aren't any ways that I can dismiss the case unless this case is before me, there's no jury, and it's in a trial. So if you requested and waived your right to a trial, by the way, Mr. Denhouten would have to waive his right to a trial, and I would have to agree. Since you both have told me you want a jury trial, or at the very least, Mr. Denhouten has, I can't decide the case. Okay, that's all.
That's
okay. It's all right. That's what I'm here for.
And I do appreciate you bring up the Constitution, because the arrest regarding when I was arrested in this manner was done ex parte. I had no notice of this.
It's okay.
With their client.
An arrest warrant can be issued ex parte. The law allows that. There are rules that allow a district court judge or magistrate to issue an arrest warrant based upon a complaint.
Under the rules, but where does it say that in the Constitution? Because I've done read that puppy backwards, forwards, upside down, sideways.
It doesn't. It just says it just says an arrest without a warrant is illegal. But the Michigan law doesn't, Michigan law tells us what we can do or what, sorry, not we, but law enforcement can do, because they don't work for me, I don't work for them. They have issued a warrant.
Right.
And they did it according to the rules.
Yes.
Yes.
And Marbury versus Madison, any law that Congress or any legislature passes, if it violates the Constitution, it's null and void on its face. I'm not here to argue, I'm just
That's okay.
making you aware of what's happened.
It's been a long time since I had that class, which was common law, where we had to deal with Marbury versus Madison. I'm aware of it, but as of right now, there's nothing to address. So bond continues. We'll see you on the 19th, sir. Thank you. We're on the record today, 28 Circuit Court here in Missaukee County. Our first case this morning is People versus David Thompson. This is file number 25-1379-FH. Mr. Thompson, you can come and take a seat. I don't know which attorney's handling it. So
We are David Denhouten on behalf of the people.
court recognizes the defendant, Mr. David Glenn Thompson, who is now at the defense table, and he is currently representing himself in this file. Mr. Thompson, as you might recall, I just need to go over a few things. The law requires me every time. Do you understand that you have the right to hire your own attorney?
That is correct.
And you understand that you have the right to have the court appoint an attorney to assist you if you cannot otherwise afford it?
That is correct.
And you also have the right to self-represent pursuant to the Constitution. You understand?
That is correct.
And you are electing to represent yourself. Is that correct, sir?
I am, Your Honor, yes.
And I think you've represented yourself in this file the entire time.
Yes.
And through district court. Okay. All right. So we're here today for two things. The first is we're here today for a pretrial conference. The pretrial hearing today is just to find out where the case is going. The case is probably, yes, just recently bound over to the circuit court after going through the preliminary exam phase in the district court. And I see that the felony information was filed on February 6th. And the court then subsequently issued, assume I did. Yes, a scheduling order. Or about, actually, that was done on February 5th. Even though it looks like the information was dated February 5th, but filed on the 6th. Now we're here again today for a pretrial conference hearing. Mr. Thompson, the only thing we do at a pretrial conference hearing is just to find out where the case is going. If there is a resolution of any kind, you guys can tell me. If not, then I'm going to ask if there are some other, I'm going to ask a couple other questions. The first thing here is see that the defendant is pending charges, and I didn't say what they were. Looks like there are 2 counts for a possession of a controlled substance. All right. Mr. Thompson, is there any resolution between this case, I'm sorry, in this case, as far as you know?
Your Honor, I believe there is.
Okay, well, hold on. I just got to ask the other party first. Because a resolution means an agreement. Mr. Denhouten, are you aware of any pretrial agreement?
I'm aware of that.
All right, thank you. That just lets me know that I've checked off that blank. What do you think is the nature of the resolution then?
Your Honor, I made a deposit with the ex parte hearing regarding another matter, equity taking jurisdiction to avoid a multiplicity of suits, putting up consideration for full accord and satisfaction and settlement and closure. To my knowledge, from what I understand, it includes all matters and all liabilities related. Now, I did realize that I should have directed the clerk to deposit that in accordance with the Judicature Act revised in 1961, Act 236 under section 600.576. Depositing funds, stocks, or securities with the court clerk pursuant to court order is discharged from further liability. And in that matter, I was the payer, so I did that. And I'm still trying to make sure all of this gets settled and closure in honor.
Oh, okay.
That would be another one of those envelopes that you.
Yeah. I understand. Okay.
If there's any other instructions or I
And you
believe
ref-
my duty that I'm aware of, but I'm willing to correct my mistakes.
Okay. Let's take a quick look here. And you were giving me a reference to the Judiciary Act, and I know it's 600, and you referenced the
576, Your Honor.
Okay. And how do you think deposit? What did specifically again? Did you deposit
A certificate of security.
Okay. And so, what security was it that you tendered?
That was consideration
Or
any outstanding liabilities, Your Honor.
okay. So your deposit of this certificate of security applies to how much was it for?
That it has been unassessed and unknown at this time, which is what I'm seeking further from the court assistance in.
All right. So, and you think that somehow takes care of this particular file?
Due to the fact that where there's a conflict and variation in the law between common law and equity, Your Honor, equity shall prevail, and equity takes multiple jurisdiction to avoid a multiplicity of suits.
All right. So are you charged with the possession of controlled substances in more than one case?
No, Your Honor, that case, I was a payer, which falls into this with the 600-576. And to my knowledge, a trust running in the background deserves to be heard in equity.
So in this particular file, you don't owe anything.
My knowledge, I do not. I have
No. So
my knowledge, I'm free and clear of liability, Your Honor.
No. Liability is a different word. Liability doesn't apply here yet, right? There's no judgment that says you owe anybody money. So there's no liability.
Thank you for correcting me.
Yeah. Now, the question here is there a resolution to the case? Filing whatever you think you filed doesn't resolve this particular case.
I understand, Your Honor.
Okay.
In equity, I thought that they took jurisdiction to avoid multiplicity of suits. So
no, multiplicity is something different. Multiplicity is generally used if you've been charged with the same act more than once, or if you've been tried more than once, then that becomes double jeopardy. Multiplicity is something entirely different. Unless you're telling me you've been convicted of the same offense already before, which I know the answer is no.
I have not.
It's okay. So, I'm sorry, sir, I cut you off.
I do have evidence that I did deposit with the prosecutor's office of potential resolution.
Okay, so you made an offer to the prosecutor to resolve the case?
Yes, Your Honor, and I've got the green card resent.
That's okay. And so what happens here is I'm just the manager of this small version of Tiger Stadium. I always use Tiger Stadium. By the way, I don't even watch baseball. But anyways, this is my little Tiger Stadium. All I need to know is that somewhere in the future, and the date is currently on a piece of paper, looks like that is May 8th, May 6th. May 6th, we've got a game. It is the Tigers. That's his home stadium. So we'll say that's Mr. Denhound versus the Twins. That's Mr. By the way, I like Minnesota. That's fine. But all I need to know is, are we playing baseball on May 6th? If the answer is either yes or no, we're going to get 2 bites of that apple. Today's the first one. The second one comes at the final pretrial conference. So today, do I keep the game currently scheduled, People versus Thompson, set for May 6th? That is all I'm here to do. Now, if you and Mr. Thompson or Mr. Denhound reach an agreement, that's between you guys. I don't care what you guys deal with right outside. There's nothing to do with me. Mr. Denhound says they don't have an agreement, which means your offer has been, at least at this point in time, rejected. So now the next question here is, so that means we don't have a resolution today. I don't understand necessarily the theory of Mr. Thompson resting on the statute that he referred to. This has nothing to do with liability, because so far it doesn't end the case. You can't pay off a fine until I order a fine. So therefore, the next question I have is, and I know that Mr. Thompson is currently on bond, so we don't have any issues there right now yet. I know there's a bond petition. The next question here is, have you gotten all the evidence, the discovery in the case, like the police report, any
I'm not
body?
sure.
Yeah,
Sorry
it's
to
okay.
interrupt
It's
you.
okay.
I'm not sure that I have it in total.
All right. So the best thing you can do is you can look at the police report, and if, for instance, it says, well, hold on. Have you received a copy of the police report?
I believe I do have one, Your Honor.
Have you received, should be a lab report from the Department of State Police, the Forensic Crime Lab?
I'm not sure if I've got that yet.
Mr. Denham, has there been a crime lab report yet? Sometimes they're running behind. Nothing works like it does on television.
Your Honor, I believe it has been submitted, but I don't believe we have a copy of it.
All right, so that means I turn over here, and I'm just going to say on my discovery issue, still,
Your Honor, I stand corrected. I do have a copy. of it.
never mind, I don't have to write that down. The next is was there a prelim?
There was, Your Honor.
Okay, let's make sure that I ordered the prelim transcript.
There is audio and video that has been submitted as well.
Okay.
He doesn't have a copy. I'm happy to send another copy.
All right, so I see that the transcript has been ordered by my office. The transcript of the prelim will be prepared and issued to both the prosecutor and to the defendant. Now, the next question would be, I'm sorry, if you have received those, you say you think you have, so I'm just going to tell you what you can do is look at the police report. And typically on the last page or two, it will report whatever exhibits they may have collected. Let's say, for example, this was well, I don't use an example, let's just use the charges. If there was some kind of baggie, that will be put into evidence. That'll be listed on there. You'll get the baggie. You'll get the test of that baggie. Now, you should also be able to get the chain of custody, which should generally come. So you just want to make sure that there's the chain of custody. Now, if the defense chooses ever to have a substance retested, it can ask for that, but it pays for it you would pay for it on your own. You'd have to find a lab, and then you'd have to come and have me give an order that says, hey, police agency, send it to that lab. So things like that. So you can ask questions about discovery. But so far right now, it seems like you have it. But again, if you look at that police report, look at the last 2 pages, it will list all the exhibits, and you're going to want to make sure you've got those exhibits. And typically there's some kind of body camera. Now, by the way, unlike what they show on television, not every body camera works all the time. Not every body camera gets digitally downloaded for some reason. I don't know why, but you just can find out that information. And sometimes, by the way, they're muffled. Good luck figuring that out. All right. So we don't have a resolution. We don't have any discovery issues. The next question is do we have any motions? Now, Mr. Thompson, inside my schedule order, I said, if you have any motions, such as a motion to suppress, you can raise it within 30 days of the transcript. So if the transcript gets provided to you, and let's just say for a random choice, March 15th, you have until April 15th to raise a motion, like a motion to suppress. Okay. Now that I've covered all that, now let's turn to this last question here. The next question here is, Mr. Thompson, looks like on February 19th, the prosecutor filed a petition asking to show cause. Now, basically alleging that there was some kind of bond violation. Particularly in this instance, the bond violation is that you allegedly failed to appear for a drug test on February 9th of 2025, and then February 16th, 2025. Now, the prosecutor could have asked for a bench warrant. He didn't do so, which is pretty common in this kind of a situation. I can tell you that either party or the court can ask to review someone's bond. And there isn't a right to a trial. There is no jury. There's no proof beyond a reasonable doubt. It's just that the court looks at it and gets to determine whether or not that's a violation. And then if so, what should I do? Should I revoke bond? Should I remand the defendant into custody? Should I modify the bond? Or should I just wag my finger if they don't do that again? Now, do we want to have a hearing on that? Do you want to have a hearing? And by the way, well, hold on. Miss Dean Stark joins us today, also via Zoom from the Wexford Misaki Community Corrections Program. Miss Stark, are you here for this one?
Yes.
I just want to ask you this question. Have there been any other alleged violations?
Two violations on the 9th and the 16th for no shows.
All right, but nothing since then?
No.
All right, thank you. All right. Has he shown up at all for any testing?
He has.
All right. Any I assume they've all been negative?
Just positive for THC.
All right, and that probably wasn't listed. Okay. All right. And by the way, Mr. Thompson, if you admit to failing to show up for those two tests, I'm just going to go with the finger wag. If they don't do that again, make sure you show up. Okay. Is it true you failed to appear for those two tests?
By mistake, I did, Your Honor.
Okay.
I apologize on behalf of the court.
As long as you've been going to testing and you've been, and it just was on a couple different events. I will note they appear to both be on a Sunday. So I'm just going to say, make sure you don't. The court finds that there's been a bond violation, but the court is not going to revoke, modify the bond. I'm just going to do the finger wag. There we go. All right. Yes, sir. Anything else?
I wish to express gratitude, and I appreciate the court in its leniency. And I also want to let the court know that every day of my life is getting better.
I'm glad to hear that, Mr. Thompson.
I appreciate the opportunity to improve.
I'm not threatening you. Say one more word and that's 30 days. 30 days.